Hello, and welcome to Child Custody Monitors, the When, the Who, and the What. I'm April Zonis, co-chair of the Beverly Hills Bar Association's Family Law Section, and I'm delighted to introduce today's speakers, Michael Hanasab, Robin Sachs, and the Honorable Susan Lopez-Gi. We would like to thank our section sponsor, White, Zuckerman, Warsofsky, Luna, and Hunch, for their continued support in helping us bring essential programming to our members. Michael Hanasab is a partner at Jamra, and Hanasab, where he focuses exclusively on family law matters, including high asset divorce, custody disputes, and complex property division. In addition to his litigation practice, he is trained in collaborative law and serves as a family law neutral for the Los Angeles Superior Court's ADR program. Prior to his legal career, Michael worked in the entertainment industry, a background that informs his representation of high-profile clients in Southern California. He is an active member of several bar associations and a regular contributor to the California Family Law Report. Robin Sachs is both an attorney and a clinical therapist, offering a truly one-of-a-kind practice that seamlessly blends legal and therapeutic skills. While her legal practice primarily focuses on the criminal justice system, Dear Co-Parent is where Robin's distinctive approach shines. Through Dear Co-Parent, Robin serves as a co-parenting therapist, behind-the-scenes coach, mediator and parenting plan coordinator, and mediator, helping families navigate divorce and high-conflict situations with both legal precision and therapeutic insight. Many professionals transition from law to therapy or vice versa, but Robin uniquely integrates both disciplines at once, providing a holistic solution-oriented approach to co-parenting challenges. And the Honorable Susan Lopez-Gi is a respected mediator with ADR Services, following a 15-year tenure as a family law judge on the Los Angeles Superior Court. Prior to her judicial appointment, she spent 30 years with the Los Angeles City Attorney's Office, where she pioneered domestic violence prosecution programs that gained national recognition. She later served as Assistant General Counsel for LADWP, handling complex litigation, regulatory matters, and major financial transactions. Judge Lopez-Gi is widely respected for her practical legal insight, collaborative approach, and commitment to resolving even the most complex disputes, which I can personally attest to. And now let's get started with today's program.
Thank you, April, and thank the Beverly Hills Bar Association. The title of this program, Child Custody Monitors, the When, the Who, and the What, kind of came out of a collaborative conversation between Michael and then a few days later with Robin. All of you who practice family law are aware of the times when you are just concerned, the parties are concerned, the court is concerned, DCFS may be concerned about the safety of the children. And it would just seemingly be simple. We have the children monitored, custody monitored, but it hasn't been simple. As a bench officer, when monitors are appointed, we get the common complaint, they're not doing their job. And when and how and what should the monitors be doing, and when do you bring them in? A simple, simplistic question or issue has turned into a whole seminar, because when you start dissecting these issues, you start realizing that early on, if you make the issues and the issues clear and the orders clear, the later problems don't arrive. So that is why we have Michael with his practical experience and Robin with handling these types of cases, putting together a program that hopefully will help all of you. The primary purposes of the monitors are obviously to protect the children during the visits, to ensure that the orders of the court are honored. And as I would tell litigants, it provides objective documentation to show that a parent is in fact a good parent, to assess the parenting dynamics, and then to prevent and mitigate false allegations. But there are other purposes that we will talk about. In preparing for this presentation, I did speak with Judge Kaufman, who's the presiding judge, supervising judge of the Family Law Department, And she referred me to the self-help court website. And I urge all of you to acquaint yourself with that, as well as some of the materials that we've provided that will give you some background assistance. Next slide, please.
So when do we use monitors? I mean, I think that this has been an evolving area, and anybody who's been in practice has seen that there's been kind of the traditional areas where, monitors absolutely clearly necessary, but then there's been an evolution of monitors being used in things that are not necessarily what one would think about, at first blush. So, the more obvious cases that where monitors get to be used or often used are in cases where there's domestic violence, where there's been allegations of abuse, including child abuse, sexual abuse, or substance abuse, where there's been either an investigation or an ongoing case or potential criminal background or current conduct or something under investigation. If there's been allegations of a parent not being fit or capable, bordering into neglect. There's oftentimes they get used in very high conflict situations where there's been kind of a mess out there. And so we find that we use these to really, frankly, get third-party corroboration to figure out what's actually going on and getting a sense of things, but also to help with the neutral transfer of kids from parent to parent. And sometimes that happens through a monitor.
Robin?
Yes.
Do you see and have you experienced that in cases that do not involve domestic violence, do not involve sexual abuse or criminal conduct of any time, the use of monitors where parents just cannot co-parent, and there is a dispute about how the children are being taken care of, including but not limited to nap times, whether or not gluten has been introduced as the potential poisoner of the child, or just in the sense of bedtime and other types of parenting issues that would not necessarily be legal issues, but lead to a breakdown of the parental relationship and therefore the well-being of the children.
Absolutely. I mean, first of all, we have the traditional, as I was kind of saying, is that we have the traditional environments where one would expect there to be monitors, right? Where there are these types of allegations out there. But in times, especially in the very early stages of divorce and or when there's been a domestic violence restraining orders that may be filed, or even as a preemptive measure of let's just get things going and let me show you that my client is actually well behaved, monitors are getting used more and more to help navigate and understand a parenting dynamic. Hey, let's see, if there really is some sort of inept behavior, inept parenting, lack of parenting acumen. And what we're seeing, and Michael will probably talk about this a little bit more, is okay, why don't we just volunteer and just to have a monitor, because it's going to help your case to just show that you are a capable, fine parent. So while it used to be something that I think that very often was used or requested by by one party kind of to show and put a caretaker or monitor there to make sure everything's going okay, I think there's a new use for people to negate allegations that there are a problem and use taking a defensive, what may have been a defensive type of intervention into an offensive intervention. In addition, if there has been a difficulty in a parent-child dynamic, it is sometimes a monitor allows for us to remove the parent-parent contact or whatever the influence of the perceived in-parent may be, and utilize monitors to assist in the reunification process so that we're taking the parent-parent contact out of the situation and allowing for there to be a neutral to allow the transfers to help then kind of do an exposure therapy, if you will, to practicing spending time with someone that a kid may be, a parent that a kid may have a difficult or resisting relationship with.
Okay, next slide. That raises the question of who should serve as the monitor. I'm going to address initially professional monitors. Now, when I first got on the bench and I was dealing with restraining orders and the concern of the safety of children in a domestic violence situation, I would often never be asked about whether or not there should be a professional monitor. On the custody sheet for the initial temporary order, I often would say, I want the alleged offending parent to see the child, but not without a monitor. And so there typically is a page on the temporary order that allows for a professional monitor, and that box would be checked. Under the Family Code, Section 3200.5C2E, that's listed in this PowerPoint that you all will get a copy of, and the Rule of Court 5.20E, it defines professional monitors. And professional monitors are required to have training, 12 hours in the courtroom, 3 hours of training on screening and monitoring and terminating visitation.
I'm going to interrupt you, Judge. Not in the courtroom, in the classroom.
Too bad I can't read.
That's okay. 12
hours in the classroom. Thank you for that correction. Screening, monitoring, and terminating visitation, and then 3 hours of the developmental needs of the children, 3 hours of substance and child and sexual abuse and domestic violence, and then 1 hour of basic knowledge of family law. One would think that that seems like a lot of training, but in truth and fact, you can have classroom training, but then dealing with children and parents who do not get along, and the concern about the safety of the children is not taught necessarily in the classroom. And so oftentimes judges would utilize early, when I was first doing it, retired police officers, retired social workers, retired persons who had experience dealing with children, but also dealing with children in high conflict situations. And the reason why that becomes incredibly important in your selection of a monitor, when you have a domestic violence situation, it seems obvious that you'd want a professional monitor. But if you have two high conflict parents where there really is no domestic violence, but that the parents just cannot agree on anything, and the child is basically the rope in the tug of war, oftentimes a family member isn't sufficient to be able to establish calm. And that is really what we're talking about, putting someone in there that can kind of reset the shot clock and make an area of calm where visitation can proceed. And for those of you attorneys out there who think getting a monitor would put a taint on your client, I suggest the opposite. I think a professional monitor being utilized initially in a high conflict case will basically show that your client is safe. Maybe not the kind of parent that parent was during the course of the marriage or the breakup, but now in a level playing field where there's a basically neutral person watching that person, I have seen parent-child relationships thrive. But I want Michael to talk about the non-professional monitor and in that circumstance.
And before Michael goes there, just for one comment, I think that there is an assumption out there that professional monitors somehow have an MSW or have an MFT, and that have all of this early childhood knowledge and skills in terms of the developmental, educational, emotional, psychological needs of children. And so you can be a professional monitor with relatively very little knowledge of children. And so that's something that should be pointed out. Now, it's great if there are the people that Judge Lopez-Gi talks about having, retired law enforcement, retired social workers, et cetera. But the expectation that that's who you're getting should not be an assumption that attorneys or anybody else is making.
And I want to just point out one other thing. Like I said, when I first began, which was now 18 years ago, there was a plethora of people who would serve as monitors with professional experience. I will say that towards the end of my tenure on the bench, that wasn't so much. Now, we had gone through COVID and we had gone through other issues with the economy. And I will say that people who became professional monitors came from various walks of life. But the one thing that I saw that was probably the common denominator that made professional monitors serve as good professional monitors or better professional monitors was the innate ability to be an individual who could not attack the other parent, basically could calm both parents down and establish a credibility early on with both parents so that you wouldn't get the complaints that I used to get in court. The monitor is siding with the other parent. The monitor has a favorite. The best monitors are people who can seemingly float above the fray. And I as a judge, I only know this when the cases come back to me with a report.
And before we move on, it's also important to note when we talk about this, think about it. 24 hours of training. That's all that's required to be a professional monitor. And of that, of the 24 hours, 1 hour is basic knowledge of family law. That's it. So I think it's very important to think when we look at professional monitors, who we select as a professional monitor. Because while there are, if you Google professional monitors, Los Angeles, or professional monitors, California, there's a list of people that pop up as professional monitors that, you know, if you've practiced in LA County long enough, some of which you know and you can trust. And there are definitely, there's a short list of those. But then there's also a list of people that you may not have ever heard of before that have completed the, quote, 24 hours of training and only 12 hours in a classroom that can now qualify as a professional monitor. That, and we're going to talk about this as we go on, that can really play a very essential role in your case, because these professional monitors are going to be fact gatherers for the court and can be really good fact gatherers for the monitored parent or the parent seeking the monitor. Because a lot of times, as we were saying, in kind of the whole idea of give it a chance if you're being asked to be monitored to prove that you are not this bad parent. You are not the parent that needs to be monitored. You're not the parent that is feeding the child gluten per se when you're not supposed to be, or you're aware of the peanut allergy, or you know what to do with a crying 2-year-old, or you know how to change a diaper. That monitor can be a great person to present evidence to the court that's a third party. But just think about when we select who, just because they're labeled a professional monitor, the family code and the rules of court, which are in your packet that was sent to you, really have a very limited, it's 24 hours, period. And of those 24 hours, it's very limited on what it is. And in fact, as of 2021, I believe, there was a extra hour that was added, and they said, wait, but that extra hour is included in the 24 hours. So again, it's a limited amount. So now we can move to non-professional.
Well, wait a minute, Michael, before
go
you
back.
do that, I'm being me again.
Let's go back to the next prior slide.
It doesn't matter. It can be either slide. It's a good intro to your slide. And you would, all of the people who are listening to this need to keep one thing in mind. A judge is not going to appoint a specific person as a professional monitor. That is not anything that we know or are going to opine on or make the selection. That is up to the attorneys, the parties involved. And so when people are picking monitors, I know that there are some favorites. And I know that some of the favorite people are favors of one and not the other. And then there's the report back to court. And then there is the, well, you know, Your Honor, that this person supports dads, or you know, this person doesn't see this as a problem. No, we don't know that. We don't know anything about that. And I think that the vetting and the understanding of the needs of your particular client are really, really paramount in the initial selection of this monitor, because we're joking about gluten. And let me just say this. When I first got on the bench, I was sitting in Pomona. And many people who were in front of me in Pomona were on probation or parole, and they had children. And they were seeing their children a week out of custody. And the issues that many of those people who were on probation or parole had with the other parent was not putting the child in a car seat, not making sure that the child wasn't at a meeting where there could be gang members. Fast forward a few years later to me going to the West Side, where the big concern was gluten. was the fact as to whether or not somebody got their nap on time. And so you need to understand that based on the specific needs of your case, a professional monitor in one case may not even see the issues that you have in yours, which becomes real important in that initial selection.
And Judge, let's just a question for you, because that brings up a good issue. There's a lot of times where one party has an idea of who should be the monitor, or one side has an idea and the other side doesn't agree. I mean, to me, I always think it's a good idea to put it to the judge to say, we've met and conferred, we've tried to agree on who a monitor is, we can't agree. And I mean, to me, there's a couple different options, and I'd love to hear what you think. It's either each side can submit 2 or 3 names with CVs or online printouts of who the monitor is and let the court decide. Or, I mean, I almost like the idea of let party A pick 3 names and party B gets to select one of the 3 as a professional monitor, because a lot of times there won't be an agreement for exactly what you said.
So let me address what I used to do. There's, the concept of one party picking 3 names and the other one selecting. I've had this scenario where none of the 3 names were good. So what I would prefer is a list of 3 names and each party's concerns or issues with that specific monitor. And in most of those cases, even though that person might have a concern, I wouldn't have the concern. I might appoint the monitor where Dad had a concern, and then I would list in the order, this needs to be addressed, that this is an issue that needs to be addressed or is a concern or an issue. If I don't think it's a concern, I'll rule then. But I need to have the issue framed so that I can look at it and not just the complaint, I don't like that person. I need to know what the issue specific, because as I said a minute ago, monitors are not one size fits all. And I think, Robin, in your experience, you've even seen that.
Right. And what I was also going to say, sometimes the selection of who in a professional monitor goes to logistical reasons. Who has the time? Who is answering the phone? Who is able to provide, and depending on the cases, it's sometimes nice to have sometimes there's these monitoring companies that will send various different monitors, and based on the age and needs of kids, we need to select someone where maybe there's going to be more consistency from time in and time out, especially if there's special needs or other things going on. So, there's a whole host of kind of the non-tangibles that are realistic parts and pieces of the selection of who should serve.
And before we move on, sorry to make you go back one more time, Katie. Before you move on, just what we didn't include too, there is an FL 324P form, which I can count on one hand how many times I've actually seen them filed. But they're supposed to be filed each time a professional monitor submits a report to the court. That form actually outlines the requirements that are set forth in the Family Code and the rules of court. And there was a question of what the differences are. The Family Code and the rule of court that are referenced are pretty similar. There's very minimal differences, and the FL form pretty much copies the requirements of the local rule, of the rule of court, and has the monitor check it off and sign to say that they complied with it.
But, to your point, they're filed with the court, but I can tell you as a bench officer, I never checked, and I don't know how many people do check. And I've never seen anyone complain, that the form wasn't filed. And the reason why we included this to all of the participants or people who are watching this is that if that form hasn't been filed and the court somehow hasn't addressed it or doesn't, if it's not there, you need to raise it, because as a professional monitor, they need to have completed this document. They need to be in compliance. And if nobody objects, the court's not necessarily on its own going to even recognize that it isn't there.
So now moving on to non-professional monitors, I think.
That's right.
Same Family Code, same rule of court, different sections provide the outline of what a non-professional monitor is. And essentially, you have to be over 21 years old, no record of a DUI, not on parole for the last 10 years. And by the way, it's a DUI only within the last 5 years. No criminal, civil, or juvenile restraining orders within the last 10 years, not financially dependent on the person being supervised, no record of child molestation, child abuse, or other crimes against a person, proof of automobile insurance if you're transporting the child, and no current or past orders where the non-professional monitor was monitored him or herself. Pretty light standards, typically. And oh, by the way, there is an FL form, the FL 324 NP for non-professional, which is also attached to your program material. Here's what's interesting. When you look at the FL 324 NP, it actually allows us, which was going to bleed into the next slide, but it allows us to kind of think outside the box. Because while the family code and the rule of court provides these requirements for non-professional monitors, it also, the judicial council form allows you to check off a box that says, well, there's alternate qualifications. And we've decided to vary from the qualifications of the family code or rule of court. And here's why. It's either we've agreed to it or the court's ordered it. So typically, in my opinion, you have non-professional monitors are typically coming into a place where one, parties can't afford professional monitoring, and a court is concerned or a party is concerned that the other parent needs to be monitored. We can't afford a professional monitor because some of them can be pricey, but we need protection in place. Or two, there might be times where a professional monitor just, the worry and concern might not lead up to the need to have a professional monitor. It might be more child-friendly or child-focused to have a friend of the family, a relative, a third party that we all know act as a monitor. Now, you have to get that party to agree to it. You have to have the party agree to sign the FL 324 form, and you have to get that party to essentially agree that they are signing on to being a witness in this family law case, which, as we all know, sometimes can be very hard to get a third party to even testify with a subpoena, nevertheless agree to volunteer to become this witness as a non-professional monitor.
You know, in cases that are not highly litigious, with probably most of the lawyers who are watching this, I have seen where the parties say, I don't care if grandma's the monitor. I don't care if the uncle's the monitor. I don't care. I don't care. It's okay. I trust that person. It's okay. And sometimes what is the phrase? Keep it simple, stupid. Sometimes it's really not that complicated. And oftentimes in those cases, the monitor basically says everything is okay and the monitor goes away. So I don't want anybody who's watching this program to think that every single time there is a monitor that there has to be a fight. There have been so many cases that I have presided over where they're either been self-represented or even with attorneys where they say, I don't care. It can be the neighbor. And they are not really looking to complicate it other than that they feel for whatever reasons there needs to be someone there. And I don't know how you feel about that, Robin. I don't even know if we discussed this. I don't think we did in our preparation, but it doesn't always have to be complicated.
100%. And actually, I've had cases that are even very, very high conflict, difficult, challenging cases. And that, once you start talking about the economics of how much monitors cost, particularly if monitors are going to have, fees are being split and both parties are bearing the burden. And once the costs start to rack up, depending when you see how things play out, all of a sudden there may be a meeting of the minds that someone may be appropriate. And it kind of reminds me a little bit, I was at a speech where they were talking about middle school admissions and who you should have letters of recommendation from. And the head of school said one of the most reliable letters of recommendation can come from grandparents, because grandparents have a unique ability to be able to judge and see how their kids are doing and have an innate desire to protect them. And it almost transfers to this a little bit. I know that sometimes grandparents can get in the way of things in terms of when there's a custody case going on, but a trusted grandparent can be an excellent monitor because they have the protective side. They've been a parent to one of those parents theoretically, and they oftentimes say it like it is. So we should not discount the non-professional monitor out there, particularly if it's going to be over a protracted period of time, and with long hours in there.
And as a cost savings analysis too, I mean, I've especially post-COVID world, there's been a lot of times where virtual visitations have been ordered, or weekly telephone calls for an hour or two, and there have been times where they've been ordered to be monitored. And to me, especially with a Zoom call that's going to be monitored, yeah, as a lawyer, I might be more inclined to think of a non-professional monitor on a Zoom call, especially if the party who is especially if the Zoom call can be recorded, because then you have the documentary evidence that you may need to say the monitored parent acted inappropriately, and you can bring in the recording of the Zoom call if necessary, and you don't really rely on the non-professional monitor to provide the evidence of that. And it also gives you evidence to see if the non-professional monitor is actually going to stop or redirect or terminate the call if the monitored parent's not acting correctly.
Is there a regulatory board, Robin, for the professional monitors?
No, there is not. They're not
So-
part of the Board of Behavioral Sciences. There is no degree. There's no licensure. It is simply, take the class and check off the class, almost like, minors council, if you will.
And kind of the problem, Judge Giss, of why I said you're looking at a very minimal hours if you actually think about it in the long and short of it. Yes, it is a lot of hours in initial work, but that's it. There's no continuing education requirement in the family code. And there's no one governing it. And like I said, if you Google professional monitors in LA County, there's a list. And practicing family law for a while, we know the ones that at least I believe are reputable, but there is a list of people that you've never heard of. And you have to be careful in who you select to be a professional monitor. It can definitely get scary on who can be out there.
Well, and along those lines, actually, I mean, first of all, even though there may not be any regulatory requirements, there are many different internal requirements that these various companies may have, right? That they do require that their individual monitors take extra classes. They may not be formalized, but these are things actually when I am helping people try to think about selecting a monitor, thinking about some of these things. And to me, and I know this often happens, we're all busy. You family law lawyers out there are super, super busy, busier than ever. And the last thing you have time to do is really, do things in advance. But if you're watching this right now, take the time to get to know monitors now. Take the time to get to know monitors and interview them before you have a case. So you can develop an independent, objective view of them and see, okay, what is their experience in training are? Who are the people? Who are the people that are responsive? How do they select people? How many monitors are on their staff? Do they provide monitors that have the ability to do 24-hour sleepovers? How many of those people? Do they have any monitors that have MFTs or MSWs on in their credentials? So one of the things, if I'm talking from, giving advice to lawyers, is start trying to do the work and interviewing and verifying credentials before you even have a case coming up, so you know who there is and you have the relationships done. And then looking at those things like experience and training. The other thing is that when you're selecting a monitor, you kind of have the objective view of what the skill level and whether or not they have, what their ability is to write a report, to witness things, to be objective, all of those kind of, hard skills. But let's also then look at the nuances that come with every case, right? We have to look at each case and each kid based on their individual personalities, dispositions. Will they connect? Are you going to have like a, how will a little tiny 3-year-old feel with a 6'8" monitor, right? Is that going to feel comfortable for the child? Do we want to look at a male versus female? Some of these other types of things that may come on based on what the facts of the case are. So you want to kind of, take a balanced view of looking at both the objective factors in terms of the skill set, but then also the soft subjective factors, and thinking, really about what is going on in the case, right? If we've got a really challenging resist-refuse case, is the monitor strong enough to be able to assist in getting a kid out of the car? If this is a kid that is likely to, double down and not want to get out of a car, Are they able to help manage difficult parents who may call all the time or may write nastygram emails or do any of this stuff? Do they have kind of those other skills that are going to be able to be addressed? And that also may be, and this is something that in our preparation, we had a little bit of debate about what, and we'll talk about more in terms of the role of the monitor, but there's some gray area where you're monitoring and watching, but there may be a need for a monitor to intervene. And what is that monitor's ability to intervene, to stop something that may be a dangerous situation, need to stop a visit, or a redirection of something, a kid goes running or doing something. I mean, the monitor is just not monitoring and watching. They're there to monitor, to intervene if it's necessary. And this is something that is subject to a lot of debate, and we'd be curious for your feedback if you want to write this into the chat or whatever. But there is, a debate out here about, can a monitor be used to model parenting skills or allow for some collaboration to help redirect and help parent, right? It's like, for example, if you see a parent struggling to connect with the child, is it appropriate for the monitor to say, maybe you shouldn't be doing this activity, maybe instead you should be sitting on the floor and playing some Legos because maybe you'll bond better. So Michael and I have had this conversation with Judge Lopez-Gi about whether or not that's appropriate. I personally think anything to support a family unit and help, like the goal is to make everyone better and make the experience good. A little bit of corrective stuff may be useful, but I'm sure Michael will clap back at me here in just a moment.
Before Michael claps back at you, I just want to do a preemptive strike. I have had cases where a monitor has suggested that one parent or the other might be more effective doing this rather than that, and maybe in a tantrum situation, or when the child seemingly is bored or seemingly has issues. And I've seen the other side angry, that, complaining in court that the monitor, is helping, quote unquote, helping the other parent. And, let's go back to the purpose of a monitor. The purpose of the monitor is to make sure that a child is safe. And so that being safe, meaning, not running out on the street, being safe, not, ingesting poisonous materials, in safe meaning that they are protected from danger. But what too often happens is that the definition of danger starts bleeding into, I don't like the way that other parent parents. That's not necessarily danger. I really don't think it is. I think people have different techniques in raising their children that are not, as I often say, legal decisions, they're parenting decisions. And so what is the difference of a next door neighbor saying, you know what, Johnny's taking the hose and squirting all the cars, and here, Johnny, take the hose and let's go water flowers, as some sort of helping that other parent. And I think the ball that we have to keep our eye on is the best interest of the child, not proving that the other parent doesn't parent the way you want that parent to parent. But then this goes back to the issues of choosing the monitors. And Michael, I cut you off, so I want you to talk.
Well, I think we're gonna get to that. My only concern is if a monitor is providing advice to the monitored parent, and I don't think I would not go to court saying that monitor is helping the parent. That's not what the monitor is supposed to do. But I would be concerned about a bias issue, because if monitor is so aligned with the monitored parent, that raises a concern, at least optically, as to whether or not that monitor is a neutral third party that's monitoring the visits, which is.
So how would you define aligned?
Well, and I'm going to clap back, Michael, because this is what we're talking about. And they may say, listen, this guy's a ding dong, does not know how to do anything with his kids, so therefore I redirect it. So maybe it's a bias the other way.
Well, but to me, I don't know if that's what, in my interpretation, that's not what the monitor's job is. The monitor's job is to be there and monitor what the parent is doing and to report back to the court what the parent is doing.
So let's assume the monitor sees that the child is just, drawing all over the walls or whatever it is, and some parents wouldn't even have a problem because they're expressing themselves, but the monitor doesn't say, look, Mary is seemingly bored. Does that mean that the monitor is supposed to write a report that the child drew on the walls? I just don't think that makes a parent a bad parent, because where do you draw there's so many parents who are just so laid back and laissez-faire that doesn't mean the child's not safe. And so I want to know from you, for the benefit of the people who are listening, what do you define as a lawyer that you would bring to a judge as aligned with one parent or the other?
Well, so it really depends. So because it's situational, and I'm going to the worst case scenario, and because I'm hoping for the best but planning for the worst. And Robin and I had this debate where Robin was, she's hoping for the best, and that's what Robin does with the co-parenting therapy, with helping people, in the therapeutic venue of what she does for a living. That's great. But if I have a monitor that does not put in a monitor report, children were writing on a wall, and I then had to tell dad, maybe we should switch activities, but rather tells dad and doesn't report it, I have a concern, because then query is, what else is being left out of the monitor report?
But no one said not to put it in the report.
Well, but okay, then play with this out with me for a little bit. There's one thing: redirect. Dad, mom, monitor parent, please don't talk about the case with the children. That's not appropriate. You put that in the report, great. Monitor parent, I think we should change activities because child is seemingly bored. Maybe we should go from the swings to let's grab the soccer ball. And that's in the report, redirected. Dad didn't notice that child was bored. I did. I told parent to change activity. Fine, that's in the report. If then the monitor decides to call the monitored parent's lawyer, per se, to say, your client really needs to do different activities, or really needs to kind of focus on this, or should get a parenting coach to help him, I'm a little concerned, because then that's not monitoring, then that's not really acting as a third-party neutral. That's really giving advice to the monitored parent, and there starts to be an alignment. And then if it continues, and I've seen it continue, where then a monitor starts making negative reports about the non-monitored parent. So for instance, non-monitored parents bringing child to monitored visit in sweatshirt, and it was 95 degrees. Well, okay, you're not monitoring the non-monitored parent. Why is that in there? And now you're also helping the monitored parent. It starts to, you start to at least paint a picture of a bias, which to me, if I'm representing the monitored parent, that doesn't help me, because I want the monitor to be an independent third-party neutral witness that's going to say that my parent is not putting the child in danger and that the monitor is no longer needed.
But see, Michael, that's where I disagree. I think it is being neutral to report just the facts, right? So if you're saying they may not be good facts for you, for example, my client, eyewitness, parent A, had trouble selecting activities. I suggested that maybe this parent should get a parenting coach because it'll be helpful for them to be more attuned to their child. That's just reality. This is what I thought, and it can be used in whatever. And this is what I thought, because a monitor is not just supposed to be a video camera of watching what's going on. Their job is to intervene if it's seemingly necessary.
But I have to push back on this whole discussion, because the whole purpose for me of monitors is to protect the child's safety. What we're having disagreement about is parenting decisions, and whether the child shows up in a sweatshirt and that means that the other parent was somehow overheating the child is, in my opinion, nonsense. And whether or not the child is bored, I mean, okay, the child is bored. But what I'm really worried about is the child safe. And if that is why a monitor is being appointed, because the child might be bored with mom or might be bored with dad and isn't having an e-ticket visit each time, I suggest that we're really misusing the purpose of monitors from my perspective. And I've seen too many lawyers get into how many angels can dance on the head of a pin argument with respect to their own biases as to what is considered parenting. And if a monitor is redirecting and includes it or doesn't include it, to me, that monitor doesn't have much to watch. I mean, I've seen where parents have had substance abuse problems, and I'm nervous about whether that child is being exposed to a parent who's either drunk and or loaded during that visitation. That's why the monitor is there. The monitor is not there to make sure that the child goes to sleep at 1 o'clock in the afternoon. If the child does or doesn't, and a parent is not abiding by those concerns, I think that this goes back to early on as to why you're having a monitor appointed.
You took the words out of my mouth. You took the words exactly out of my mouth, because that's exactly what I was going to say. Is it really depends on what the purpose is for the case and why we're having them there and what we're trying to solve. And if it is an issue of, okay, I'm just going to agree to negate some of the issues or some of the concerns, or to corroborate some of the concerns that have been there, and they have to deal more with these kind of parent-child contact issues, then some of this observation may be more relevant.
Well, and you also have the local rule, California Rule of Court 5.20 I, which deals with conflict of interest, which makes it clear that the monitor is to maintain neutrality, not refuse, and should refuse to discuss merits of the case or agree with or support one party over another. So that's kind of where my pushback is that you have a local rule that states that. So if the monitor is discussing or trying to support one party over the other, and there, I think it's a fine line, but that is where the bias and conflict of interest comes into effect. And I mean, now the local rule does not go into correcting behavior as a conflict of interest, but it's an argument. I mean, it does go into, not to be financially dependent, not to be an employee of either of the people, and not to be in an intimate relationship. But I do think that it's clear that they're to maintain neutrality and should refuse to discuss merits of the case or agree with or support one party over another.
So we're getting to this discussion, and I think it leads into crafting the court order, as to my point earlier, as to what actually is intended by the parties in getting a monitor. So this is something that Judge Kaufman and I discussed, and I just want to underscore, bold, and make clear that whatever your concern is needs to be put in this order. Judges are not going to guess for you. If you think that a monitor should not be helping the other parent make the child not bored, then put it in the order, and somebody can argue it, and the judge can make the decision up front if that's going to be determined to be a concern. But the easy things, who selects the monitor? And can the monitor be terminated, and by who? Because I've seen orders that talk about the child being monitored by a professional monitor, but with no end date. And that buys a request for order for termination. So at least put it in there, or at least under what terms the termination would occur. So you're not just left with this order that basically violates the rule against perpetuities. And, about reporting requirements, this is when you want to have specific issues reported and what are the concerns. List the concerns. And if the initial concern is sobriety, or the initial concern is that the parent doesn't pay attention and falls asleep, write those issues down, because that's what the monitor is going to basically need to know, as well as the custody visitation. And if there is a child who doesn't want to get out of the car or doesn't want to go, what is the monitor expected to do? And I think that needs to be discussed, because it's often raised in court. The child doesn't want to get out of the car. Are you expecting the monitor to physically take the child out of the car? If that is an issue, it needs to be addressed in the order under what concerns Does a child get forced out of the car? If the child is 2, it's different than if the child is 5 or 6. And what kind of emotional distress are you going to put the child in? And if the child doesn't want to go, it needs to be addressed in the order as to what expectation there is for the monitor. And also in cases of disputes, if the monitor is not the judge, is not the referee, this is, not a WWW fight. So if in fact it is left to be a dispute, the monitor can just note it and leave it. And then I think that no monitor has to be present in prohibited behavior. If in fact there is drugs, the monitor can terminate the visitation. And that needs to be said, because I don't think a monitor is required to sit with a parent that's inebriated or intoxicated or in any way impaired just to finish the time. It has to be specific. And again, avoid vague language. I really think that, included but not limited to is a problem. If you've got some real concerns, list them. I'd like to hear Robin's point and then end with on this slide with Michael, because you're the one, Michael, who has come into court many times saying the monitor has not been complicit with the order.
Well, I think that, first of all, just, there's actually a rule kind of in the social worker therapy world that if there's an issue with the professional, the first thing to do is to address it with the professional. That's actually like a standard ethical requirement in the therapeutic world. And I think that that would be something that would be, obviously you want to have the order as clear and concise as possible. But the reality, as we all know, life is life. You cannot possibly account for every single possible scenario that could happen in the real world in a court order. We can't do it in terms of when we do judgments. We can't think of it in stipulations necessarily. And it's certainly going to sometimes be a problem when we're crafting an order. To the extent that we can define certain roles, I think, make sure that we define the authority and what the scope of kind of what the monitor is to do and not to do. Obviously, that's great. But then the question is that, there's different kind of rules of thumb, and kind of monitors have their own rules that sometimes don't even necessarily make its way into court orders. For example, there are a lot of monitor agencies that have an internal rule that they will not allow gifts to be given between parent and child on a monitored visit, or that they won't allow phone calls, like if the child, if that's during the middle of the monitored visit, the parent could not call a grandparent or another person or whatever. So we have to really think about and have those conversations if any of these scenarios come up, and have the conversation and talk to the monitoring agency kind of about what are your internal rules and should those be incorporated into the court order.
And I'm going to work my way backwards on this slide for a second. Where it says avoid vague language, detail is critical. So a lot easier said than done, especially when you have a DV and you're going in for a temporary restraining order and you check that box that says monitored visits, because at least when you're filing the initial TRO request, you don't get to talk to the judge. It's very hard to attach attachments to those forms, and if you do, whether or not they're even going to be looked at the initial granting phase. So to me, a lot of the detail and being detailed in the order comes at the first hearing on the TRO request. Because a lot of times you submit the monitored visit, the judge checks some boxes, you might list a name for a professional monitor, the judge might leave it blank, the judge might check the box that says one parent pays 100% of the fees, but that's it. There's no real change on the forms. But a lot of this comes in on round 2 when you're there on the first hearing that's set within 21-ish days, and you assume one party's going to be asking for a continuance, and you're going to say, and you either have a no custody order or a monitored visit order, and you're going to ask for detail to the order, because if you don't have the detail, you have issues arise, and the issues can arise, for instance, of what are the prohibited behaviors? Now, the monitor and the family code sets out, that monitors can, if rules of the visits have been violated, the child becomes acutely distressed, or the safety of the child or the provider is at risk, The visits can be interrupted, rescheduled, or set for a later date or terminated. But that's a broad subject. Are there certain behaviors we don't want? And I mean, there are different rules for sexual abuse allegation cases versus DV cases versus I just want a child being monitored because I'm afraid dad's going to talk about a case. So are we going to include in the monitor order, the monitored parent shall not talk about the case to the monitored child? If you want
But that's a rule. So I don't have any problem you putting that in. That should be in almost every custody order anyway, because that is the law, even though I don't think anyone knows that or cares, but it is the law.
well, it is, but is it in the monitor order? Because
It should be. It should be.
So I mean, that's where the detail goes in. You are putting in your hand because this order is what you give to the monitor, and this is the rule and the guideline that the monitor is going to follow for the monitored visitations for as long as it's in effect. So are we where are the monitored visits going to take place? Are we concerned that the monitored visits take place at the monitored parent's home? Do we want it in public?
Typically, Michael, my experience on the bench is that those specific points are included in the order that I sign. Where, when, for how long, and who's going to do the transportation. Those seemingly are, monitor orders, one. I mean, they're elementary.
I agree with you, but that's not on the DV form, and you get a DV order without an attachment. You don't have that.
That's why we're having this seminar now, to tell people we need it.
Right. So I think that's very important. I think it's also the more detail, the better. So for instance, are grandma and grandpa allowed to come with a monitored parent for a monitored visitation? If you don't want it, include that they're not allowed to be present. Because otherwise it's vague and then it becomes a dispute. And the same with reporting requirements. You have a monitor report. You now have your hearsay Sanchez issues. Are we going, and now a court can't order Sanchez and hearsay to be waived. The parties have to stipulate and agree to that. So are we going to agree to that, or are we not going to agree to that? All of that has to be thought about in the order. Now, some can be ordered, some can be agreed to, but all of that needs to be thought of when we're coming up with the order. And you also have to keep in mind with payment, a lot of times, and Judge Giss and I were talking about this with Robin when we were preparing for this, and the bench may not be aware, a lot of these monitors have their own written agreements that the parties have to sign. And these written agreements include who pays for what for the monitor. So even though the court order says parent A pays 100% of the cost, your client's now going out to sign an intake agreement with a monitor that says they're going to pay 50% of the cost of the intake. They're going to pay for fees and costs for the deposition if they subpoena the monitor. They're going to pay for the fees and costs for the monitor to appear at court if they subpoena them to appear at court. So if there's something that's thought differently, or we want to include that the order supersedes the monitor agreement on payment, or we need the monitor to change his or her agreement based upon the order, all of that needs to be thought of in advance so that when you go into court, there's not a dispute versus, well, the order says that dad pays 100% of the fees. I subpoenaed the monitor didn't show up. Well, your client signed a contract with the monitor saying that if they subpoena them, they're going to pay for them. All of that needs to be considered and presented, at least at the initial phase, if at all possible.
Well, and that goes back to my point of get to know who your monitors are well in advance of crafting an order so that you know the nuances in the contracts and the procedures and the rules and the issues. And sometimes it's a very helpful way to get information of what goes into the order is to ask the monitors, what types of things would you like to see in the order? And a lot of them have suggestions for you.
And I can tell you there are some that have been monitored for a while that will give you a packet with what they propose of sample orders that are beyond helpful.
And I hope the purpose of today's seminar is that, the lawyers have the ability to streamline and make the court aware of the issues. We're not going to be aware of a conflict of interest. We're not going to be aware if people are not following the procedures unless somebody brings it to our attention. But before there can be anything brought to our attention, it has to be clear in the order. And as Robin said, there's no way you're going to predict or figure out every which way it can go wrong. But at least at the beginning, if you understand the point of the monitor and what you specifically want that monitor to do and what you expect and who's going to pay for it, and even include that this order supersedes any requirement by the monitor, you're at least being made aware of potential problems in the future that don't have to exist.
And it leads to and this also kind of to rewind back to the judicial council forms, the FL 324 forms. If we focus on the monitors signing and submitting them, you're also getting them to agree that they're going to comply with all the requirements of the family code and the rule of court, so that if they violate it, they have submitted a document saying that they will comply with it. They violate it. To me, I go to court to say, Judge, we need to replace this monitor because this monitor is not complying with the rule of court or not complying with the family code, has a conflict of interest, is taken and whatnot, and they've agreed to comply with it. They're not complying it. There now needs to be a replacement.
And just so the parties who are listening, or counsel who are listening to this, I will tell you that on some rare occasions, it did not happen very much. People would bring issues about the monitor and their failure to comply, or their issues of conflict of interest. And yes, there is a hearing because it's important, but I can think of specific cases where the monitor was replaced. It just wasn't a fit. And but the judge isn't going to know if it's not in the order and if the parties don't tell us.
So this goes on to managing monitoring relationships, because I see that we're running out of time.
And we've talked a lot about a lot of these things. And I think, the main thing is to really, especially from the therapeutic point of view, is if you're a therapist and mental health provider providing co-parenting work or doing work with individual folks, what in preparation is really helping to prepare for monitor visits and destigmatize the monitoring process. Because sometimes this could be a really, really helpful process to help take out the steam of what would be otherwise a high conflict situation. In addition, I'm a big believer and think it's great when we can support collaboration. And that's been the best part about doing this speech with Judge Lopez-Gi and with Michael, is that we can talk about and recognize, okay, I think this, you think this, let's figure this out. And we can model for our clients, and we may not necessarily all share exactly the same opinions, but we can find a solution that's going to work for a case in a way that's workable. And I think the more that professionals can collaborate and talk about it and manage our clients' expectations, the better chance of success.
And I want to say this, even though, I'm not sitting on the bench again, I pretty connected with many of the members of the bar. And, I can speak for myself, and I believe a lot of my colleagues who are off the bench have no problem answering questions about this, in the sense of give us a call as to how you think a problem with an order is. Because at the end of the day, if you bring a request for order to the court, or you return back on a report from a monitor, and there's been a lack of compliance, or there's been a concern, we hope that this program at least lets you know how to frame that question or that issue to the court. We don't have all the answers, but I can tell you a clear, concise order from the beginning will certainly help get you through the door to get somebody who, if not the appropriate monitor in this case, a better monitor. Thank you.
Thank you. And we are here as resources. Feel free to reach out to us through the Beverly Hills Bar, or I think our contact information is somewhere on our materials. If not, you certainly know how to.
And there were materials that were attached so that every participant will get the materials.
I'm just looking at the questions that came in. Let's see. I'm going to put this to Robin and the judge. When or if it's appropriate, and I think we sort of answered this, for a monitor to pull a resistant child from a car. From a therapeutic side, Robin, to me, I think it depends on what type of monitor it is, number one. So,
well, I'm going to say that is generally, I think that monitors will be hard pressed to put hands on a child, and I would not recommend putting hands on a child. That's just not something that's overstepping unless there is some sort of very specific order or an agreement in advance where you have a special need, or it's okay, maybe to unsnap a kid from and lift him out of a car seat. But a resistant child from a car, that is beyond the scope, I think, of a monitor's role. And I would not recommend any monitor do that without specific orders and direction.
I agree. And I actually think if a child doesn't want to go or is resistant, the monitor notes that and it's reported back. And if appropriate, a court is addressed, it is addressed to the court. But I certainly am not in favor of anybody pulling a resistant child. I mean, if a child, like I said, a child's 1.5 and crying, yes, you can take a child out. But when a child is 3 or 4 and kicking and screaming, that is just not going to be helpful. And so,
and that goes to skilled monitors. Frankly, a skilled monitor can use words and help cajole maybe a resistant child out of a car with effective use of words and not physical contact.
Correct.
And I mean, I even think a skilled monitor can probably come up with an alternate solution. So maybe it is, mom, child's being resistant. Why don't we drop the child off here with me, hang out for a little bit, and then you leave and leave the child with me while dad comes to join me, or come up with a different alternative. I don't think pulling a child out of a car is, going to be a wise move for a monitor. Another question, I think we answered, but let's just, will a court consider removing a monitor over the objection of one parent for conduct that violates rule of court 5.20?
If it's brought to the court's attention and the court is able to inquire, which is what I would do, yes, if it's appropriate, no, if it's not. I mean, if a parent objects, which is common to the conduct of a monitor, I've held a short hearing and asked the questions, and sometimes the monitor is removed and sometimes I don't think it's an issue. But I believe that courts want to know about it because they have to go forward for the protection and well-being of the child.
Well, and I think it's important, again, it goes back to I guess it's a practice pointer, the detail in the order, because if you have an order, and let's say it's a monitored parent that's complaining about the conduct of the monitor, if you have an order that doesn't indicate who and how a monitor can be terminated, a monitored parent can terminate the monitor and decide to hire someone else if you don't have a monitor's name listed. And that could cause a lot of problems. So again, it all goes down to the more detail you put in these requests and the orders. And I mean, I think, Judge, if I handed you an attachment, whether it's for a DVRO or a request for monitors that has a list of requested orders, I mean, to me, I think I'm helping you. And I mean,
you are. And Judge Kaufman would say the same thing. Yes, help us. Don't make us guess.
I mean, I recently heard a judge say, your job is to help me count. I was sitting in court and the judge was in the audience and the judge was like, counsel, your job's to help me. Help me help you make this easier. So to me, handing the court a list of proposed orders of what you want with the monitored visitation, that's really the best path forward.
I don't know a colleague of any, either on the bench or off the bench, that I've ever served with who didn't appreciate a proposed order. Doesn't mean we might not edit it or mark it up or add something, but it really is helpful because you know what the issues are. You know what the concerns are. Yes, we're reading the paperwork, but we can't guess all of the issues that you know from your client.
Well, I think we want to thank everyone for attending. Hope everyone found this useful and helpful. And as Robin said, if you have any questions, don't hesitate to reach out.
And again, thank you to the Beverly Hills Bar for giving us this forum.
Thank you.
And thank you for Katie at ADR for helping us put together the wonderful slides that, trust me, Robin and Judge Giss and I could not have done without her help. So we want to thank her as well.
Thank
Thank
you.
you. Okay. Bye-bye.